Morning. We now call to the order the committee conference on House Bill 180 and Act increasing the penalty for buyers under the laws regarding trafficking in persons. Anyone wish to open up for discussion?
Since I was a sponsor, the bill, I do have a couple of questions. Let's look at the House bill. I guess the question for the House is, what is the difference in the age? You have a section that says 3 years difference. It's on the second page. What if the age is more than 3 years difference? Then what happens?
Are you referring to Roman numeral 3B?
Yes,
On the,
on the second,
passed by the Senate, okay.
by the House,
Oh, by the House.
by the House, right.
Okay, well, I can't answer.
The part
for the
that
House.
says, for the person who's 13 years of age or older and under 16 years of age, and the actor is 20 years of age or under, where the age difference between the actor and the other person is not more than 3 years. So if it's more than 3 years, then,
This
What?
section, that section would not have applied.
so then it would revert back to section A,
And
class A.
yes, and in the idea behind that was that the mindset of someone who is, let's say, 18 or 19, it may be different than some, if they were to solicit someone who was 15 or 16, as opposed to someone who's 50 years old. Both of those are illegal, should remain illegal. They're crimes and they're both supporting the market for human trafficking. It's just the mindset of 19 will like presumably be different than that of 40, 50. We'll say 37. That's something like it. It's not, I think it's a different offense. It's the same offense, but I think one is more egregious than the other. But my understanding that provision was taken out and removed by the Senate.
Right.
And in having conversations with different members that were sitting here today and some people outside this committee, I understand why taking it out. It's while my point may be valid and logical, it's also makes sense to also not have it in there because, again, it's still a crime. And I said this in the committee hearing in the House, and Criminal Justice Public Safety Committee, buyer beware.
Exactly. As far as the Senate version, my question is, so the class A relates to trafficking victims under the age of 16, correct?
Correct.
Okay. So 16 and 17-year-old victims then fall into the class B felony?
17 and 18, and it revolves around the age of consent because the age of consent is 16. We had some difficulty with 13 years and that 3-year
Right.
time period because we felt that there are children that are younger than the age of 13 that are also trafficked. So that's why in the new section B, we changed it to a class A felony, and we have for the person who is under the age of 16. And we wanted the harsher penalty for that because they're not capable, legally capable, and you could even argue intellectually capable of consenting to a sex act with an older person. Or even you could even say, someone who's 18 or older. The first one, we kept the class B felony because of the age of consent. You can give your consent at that particular point in time to consent. Even though you are being trafficked, you can say yes or no, I'm not going to do that. So our emphasis was really on the 16 and younger because of the age of consent.
Yeah, and the carve out didn't really make sense to us because, again, we're talking about trafficking, as you know, this is not, these aren't relationships.
Right.
And so the carve out really didn't make sense based on what you talked about as a overall crime.
So again, if we're talking about a 17-year-old victim, then we're talking about the fact that the offender would be charged with a Class B felony. Is that correct? Okay.
Correct.
And then the other question, why was the removal of the section on the knowledge of an actor not knowing the age of the person? That they cannot use that as a defense? Because that was a bill I worked on several years ago. And I just feel that, like Daryl said, it's this buyer,
Yeah, I see that. Yeah, we do
buyer
have that.
beware. you know?
Yeah, we do have that in the first section.
Right, but not in the second. So does that mean it's not applicable to the second section?
Maybe that is something that we can talk about.
Yeah,
today,
I
the second
think-
section.
Yeah, I think we can add that to the second
That
section
would,
as
I think
well.
that was a drafting sort of
Yeah,
thing.
Good.
it might have been a drafting, and also, I mean, you should know if someone's 16 or younger. I mean, granted, there are a lot of adults, and I'm going young adults or teenagers, and this applies to both men and women, although we usually just think of women being trafficked. Young boys are also trafficked as well. That they, you should know. You should know anyone between the ages of 17. You really should. But if you have a 10-year-old, I mean, come on, you know that that person is not capable of giving consent, even up to the age of 16, which is the legal age of consent. That you really should know who you're having a sexual contact with. That, but anyway, but I do think that perhaps that was an oversight that, and we can talk about an amendment to put that in there as well.
Great, because
But,
my feeling was, like Daryl said, Representative Jones, that buyer beware is definitely, and the other part of it is the fact that you're committing an offense when you're buying sex with anybody in the state of New
Yes,
Hampshire. It's a misdemeanor. So you've already broken the law.
correct.
So therefore, to use as a defense that you didn't know the age of the person you had sex with, I don't think that should be allowed to the offender
Mhm.
because they've already broken the law. And this is just, this step is even more egregious.
What we really concentrated on was the fact that we felt that there should be stricter penalties for children, for someone who traffics in children and someone who buys sexual services from a child, rather than someone who is legally able to give their consent. So Mr. Chair, we would have no problem in adopting a compromise amendment, putting the language, neither the actors lack knowledge of the other person's age nor consent of the other person shall constitute a defense to a charge under this paragraph, to include that in paragraph B.
I would support that. Any other thoughts or considerations?
No, and I just wanted to say though, that anybody who has been trafficked, these people, these reps know, have heard testimony from, victims. And it stays with that person for life.
Yes.
And so, we don't want to minimize penalties because of ages. We want to acknowledge that it's egregious, no matter what age of the child. So that is just something I needed to say.
Thank you.
And I just point out that I think that, again, this is a fair compromise between both divisions here. So
I agree.
let's see if I word this correctly. If I don't word this right, someone correct me so it's official.
Okay.
So the House is not, we're not receding our position of non-concurrence, but with the Senate amendment, but we will concur with an amendment that addresses paragraph 3B, Roman numeral 3B, that takes the language that neither the actor's lack of knowledge of the other person's age nor consent of the other person shall constitute defense to a charge under this paragraph, provided that there is an amendment that simply adds that provision from Roman numeral 3B the House would then proceed and concur with the Senate. Is that
Absolutely.
Yes. Are you all set with that, Senator French? You have the agreement.
in agreement? Excellent.
Thank you.
Thank you.
Thank you.
You all ready to rock and roll?
Yes.
Sure are.
Good morning. We will now call the order the committee of conference on House Bill 239, an act relative to the prosecution of certain assaults against minors. This is a bill that originally passed in the House that was then subsequently amended by the Senate. Before we begin, let's just start by letting everyone introduce themselves. I'll start with my.
Harold Fred, Senator, District 7.
Sharon Carson, Senator, District 14.
Morning, Becky Whitley. I'm the senator from District 15.
And Ray Newman, representative from Hillsborough 29 National.
Scott Wallace, Representative, Danville, Rockingham 12.
Jennifer Rhodes, Representative District 15, Cheshire County.
Representative Darrell Abbas, representing Rockingham County, District 8. And I think just to begin, we'll start with if someone could explain the amendment that has been added to the original bill.
Thank you very much, Mr. Chairman. This bill was a little problematic for us because we only had the testimony of prime sponsor. We had no one from the legal community, no one from advocates, whether they were legal advocates or children advocates or nothing, just that. And we felt uncomfortable with the 6 years. Originally, I believe we had moved this bill inexpedient to legislate. But in talking with some of my colleagues, we decided, okay, let's see what we can do. And so we brought in a floor amendment that we said 3 years. Why don't we just do 3 years? So in talking with my colleagues, what I would like to do is offer a compromise to the House in which we will have an amendment which would, if you look at as introduced, section 1G, notwithstanding subparagraphs A and B for any offense under RSA 631(1), which are the serious offenses where you're talking about rape, murder, real physical harm, that we will go to the 6 years. But for RSA 631(2), which is usually second-degree assaults, that we will go to 3 years. And that is the compromise we will offer to you.
Mr. Chairman. I
You're recognized.
thank you for that compromise. One of the concerns that I have is that I don't believe that a person that is a victim of these crimes necessarily sometimes even realizes or experiences the true effects of this assault at the age of 21 or 22. And if you take a person that is 18 years old, maybe recently graduates college at 19, 21 years old, comes into the rural world per se, a lot of times that's when this kind of really hits them like a sledgehammer.
Mhm.
And they kind of tend to go backwards a little bit into a shell. And also that is whenever they have the courage more to come out to talk about what has really happened. So it almost feels like, well, if you didn't do it in time, then the punishment is extreme. So
Mhm.
I feel very strongly, and I know our committee felt very strongly about the 6 years, and I just don't think that it should make a difference. What was done was not okay, period. And I would just really encourage you to think about that.
Our concern was that the further you get away from the incident, the more difficult it's going to be to prove it. Memory issues, other people that were involved, the other person or the people that were involved. I mean, it just becomes harder. Just becomes much harder. And so we felt, just based upon the testimony we had, we understand that. We know that there are times people have repressed memories. They don't realize what happened to them at that particular time. But again, we did not get the testimony that we needed from the legal community and or the other types of advocates. So that's why originally we just said, look, we don't have the testimony we need. we're just gonna ITL this, send a message to the, talk to the prime sponsor. Look, please file this again, bring the people forward to talk with us about this. But again, in reflection, we said, okay, wait a minute, we'll divide it in half. We'll go 3 years. And so that's what we did. And so now we're willing to go, okay, for the really serious crimes, we'll go 6 years. But for these other types, the lesser crimes, we'll do 3 as an effort of compromise. So I'm gonna let you do that.
Yeah, and I think sort of thinking through, you know, I see what you're saying in terms of, you know, when people will come to the realization that something happened. And of course, you know, sometimes it doesn't happen when they're outside of their home, right? So sometimes someone who is a victim is under the care of a relative, and that's the perpetrator. And so, you know, 3 years from the 18th birthday does give the additional 3 years to sort of be out from under even the legal provision of the person, the perpetrator. So I think it is a compromise position. I think, you know, if we get additional testimony next year about whether 6 years is more appropriate based on brain development, I think that would be really important testimony to know the brain development of someone from 18. But I think this is an appropriate compromise based on our constituents.
It's no good question for anyone sitting here, but this has to do with civil liability. Did last term, I know there was a Senate bill that would have made it, had erased the statute of limitations on a civil case for sexual assault cases.
That was-
Is that now?
I think we, oh, you went there. I'm
Yeah.
sorry. Yeah, I think, I'm not sure if that was part of an omnibus bill or not, but I do remember Senate Judiciary had that. I believe that it was passed. I'm gonna take a chance here and say, I think it was part of an omnibus bill that was passed by the House.
I think initially it was a standalone that got then put into
Yes.
it after
Right.
the pandemic began. Not that civil liability is necessarily justice, but at least that there is no statute of limitations on that. So
Right.
that person could still
And
have
any-
their day in court, and
Mhm.
I'm not saying money would solve the problem, but there's something to keep in mind. I'm bringing it to everyone's attention.
And I think 3 years from the 18th birthday is still like dramatic progress from what we have now, right?
Correct.
The current law is really problematic, and we all recognize that.
So if I understand correctly, the proposal is for first degree assault. That would be moved back up to 6 years, but anything second degree would remain 3 years.
From the
Yes.
18th birthday.
Yes.
From the 18th birthday. correct?
Yes.
I would agree to that for compromise. I just really have to say that I don't think limiting a person when they're in this situation to an age, I feel like it's almost telling them too bad, so sad. You know, you didn't come out soon enough. And the whole culture that we're in, the world that we're in now is to encourage people and to tell them that they're limited on how long they have to do this. I mean, it's really, really hard for a person that is in that situation. And, you know, Senator, you made a great point, right? A lot of these people are in situations where it very well may have been a family member, maybe some in their own household, and it takes them to get out of that. So I almost feel like telling them, well, you didn't do it in time. You know, I personally don't think there should be any limit, but I recognize there needs to be. I would agree to a compromise because it is better than nothing. I just really feel like I need to say, I would really encourage you to just make it be longer, not sooner.
Last term, there was a bill proposed in the House. It didn't make it out of the House, but I recall they would have had no statute of limitations for criminal offenses. I think not many people supported it. I know I did. So I'm with you on expanding even more, but I kind of tend to agree in the spirit of compromise, and because what we have now, if we don't come from, what we have now is worse. I mean, we all agree something needs to be done.
I agree.
Someone said that.
I agree.
I think for the more serious offenses, at least that would be the 6 years, and if at any point in time we think 3 years is too short of second degree assaults, I'll co-sponsor it.
Thank you for standing up. Situations to represent.
So I just have a question about the difference between 6, the difference between 3, and going by the more serious offense, a little less serious offense. Maybe in misunderstanding, and maybe I need a better understanding of what the statute of limitations does. I mean, if one of these crimes were committed, then the statute of limitations would basically, I think, protects the perpetrator. It seems like that's who by changing these number of years, it affects the perpetrator, that the victim then has the opportunity to report that crime. So I agree, I think it should be longer rather than shorter. And I don't see really the need to compromise at all from 6 to 3. So I'm not really in favor. Maybe my misunderstanding is.
And I agree with you up to the point that if I got everything I asked for in every single bill, the laws would be very different. I actually agree that I would be okay making it 9 years or even 12, because nowadays with some of the technology we have and some of the DNA databases, you're able to sometimes, you can always find the person. So, and now we're dealing with minors who, you're not even old enough to consent to testifying. So I'm right there with you, but I think, I suppose doing nothing is worse than, I think the compromise is fair, considering that it's first degree, that assault, sexual assaults, that's the serious, most serious. That's not to undermine second degree. That's also serious, but I would be reluctant to let this one slip away, because where we would be is back square one, and I'm confident that what the committee, the House Criminal Justice Public Safety Committee would do, but I see us repeating ourselves. We'll be sitting here again next June.
I would not want to see the bill slip away, but I'm not sure that I agree that compromise for the purposes of saying we compromise to get the legislation. If that's the only way to get it, then that's how we'll get it.
If you want to try to convince, I would get, the floor is yours. They're very reasonable. We're all reasonable here.
Well, I
We're all
understand
it's
that.
casual.
And I mean, you get in a situation where you have some of this may be within a family, repetitive or whatever, it could affect a whole bunch of minors. I just don't see a need to change the statute of limitations. If you don't have a case, you don't press the case. So, I mean, everybody's saying, yeah, that we should have higher ones, but just to compromise, to say we compromise, fine, but that's what we're going to do, that's fine.
In fairness to that, if I thought compromise was unreasonable, I wouldn't compromise. I'm not saying that I'm going to leave here celebrating, but at the same time, I think the compromise is reasonable being asked. I don't.
My question was that in the legislative end of it, my question was just to understand that what I thought about statute of limitations. I think they should be longer, particularly for this. So that's my opinion. That's what
It's a different question.
Right, whether we should have statute of limitations,
Yeah,
right?
That's a very different question. And I would just like to make the point, Representative, we went from killing this bill to now we're at the point where for the serious offenses, we agree to 6 years. The less serious offenses will go to 3 years. So I think the Senate has moved on our position a great deal. It's unfortunate that we just did not get a lot of testimony on this bill. We just had the prime sponsor, and that's it.
And just so everyone understands who's following along, 3 years, 6 years, it may sound short. This is a tolling statute of limitations. So you can have it's a tolling statute, meaning hypothetically, if you had a victim that was 13, for the first, once they reach 18, that's when the clock starts. So it's perceivably longer than 3, longer than 6, and for, good reason that
That's a good
you
point.
told it, so it's, you could be prosecuting or trying to prosecute someone for an offense that happened 15 years ago, 10 years ago.
And on that point too, I'm wondering if there was testimony provided about why 6 years was more appropriate. Is there any?
Um,
From 18.
If I may, we had quite a bit of testimony in
Yeah.
this regard in our committee hearing.
Yeah.
And I think part of it is based on the development of the adolescent and
Right.
child
Yeah.
brain. Once they reach the age of around 24, 25, young folks were more able to comprehend what had happened to them and may be able to
Right.
speak to the case.
Yeah.
So I think that's what this is.
Some of the
Great.
testimony I remember was that at a younger age, well, for all children and minors, it said that your brain during that period relies on mainly the part of the brain that is emotion. So there's a lot of emotional thing tied up with that. And it goes to a different part of your brain when you get to be 25. And in the meantime, most of the things you're doing are emotional. So it might be even something about where people at that age of 23, they remember the statute of limitation. Somebody might not realize till they're 23 or 24 that what they thought was perfectly okay, or they suddenly figured it out. So I don't have a problem doing the statute of limitations because we did have that kind of testimony. Why 6 years?
And another thing is, that we heard, it was as ludicrous as this may sound. When this is happening to a child, it's perfectly normal to them. They think it's very normal. That is their normalcy. Right? To us, it's hard to imagine because it's just that ludicrous. But to them, 7, 8, 9 years old, I worked in a school. You would be amazed how many children think that happens to everybody. That's very, very normal to them. So again, once they reach a certain age and they start to experience more life, and then that's when things kind of start hitting them left and right. And unfortunately, a lot of these people end up having to resign from their jobs, live with their parents. It's really, really hard. I just don't think that we should. There's something that we should handcuff them to that, but that's the best we're gonna come up with. I'm not letting it slip away, I'll tell you that.
So let's, in regards to there's no amendment officially, but the proposed amendment, which would, I'll just say it again, it would be for any first degree, we change it from 6 years from the statute of limitations, 6 years from the 18th birthday. For any second degree, it would be 3 years from the 18th birthday. Does anyone have any objection to that, if that were to be put forward? And would we all give that our blessing?
Yes.
There we have it.
Thank you.
Thank you, everyone. You're now adjourned.
we're good.
Good morning. We will now call the committee a conference on House Bill 296, an act establishing the crime of unsolicited disclosures of an intimate image. This bill that passed in the House, that was then amended, subsequently amended. But at this, before we get into that, we will now introduce the members that are present.
Senator Carson, I represent Senate District 14.
I'm Representative Allison Nutting Wong. I represent Nashua or Hillsborough 32.
Representative Scott Wallace, Rockingham 12, the town of Danville.
Representative Jennifer Rhodes, represent Cheshire County District 15.
Representative Darrell Abbas, I represent Rockingham County District 8. And at this point, I understand that there's an amendment already prepared. So rather than maybe discuss what was amended when it was in the other branch, we can just discuss the amendment. Has anyone had a chance to review that, look through that? So to sum it up, what inspired this was, in both versions that passed had language where in order to meet the burden, you have to prove the intent to harass. And it was raised to, or at least brought to our attention, that to prove the intent to harass would be very difficult to prove unless it was something more of a repeat type of situation. So considering the offense would only have been a violation offense, it was found that this law would have actually been very harmful because it wouldn't have been something that was really enforceable. And although well-intended, may have left something to be desired because it wasn't going to accomplish its goal. What I can just say from speaking with, it's not that law enforcement officials won't enforce violations, but that's a lower level offense. So it's naturally going to be a lesser priority. So it is better for this to have it at least be at the misdemeanor level. So what the amendment does, it makes the first offense to be a misdemeanor. It does not specify whether it's a Class A or a Class B misdemeanor. That would be at the discretion of the county attorney on how they wish to prosecute that. The difference obviously being a Class B misdemeanor do not entail any jail time, at least the potential for. If there were to be a second offense, presuming that there was the first offense, there was already a conviction, that would then elevate the charge to the potential of a Class B felony. And these have to do with when the lewd images are sent, they're unsolicited by the person receiving them. And what this also does is that it takes us where if the recipient does not solicit the photo and that recipient is a minor, that in and of itself would then be a Class B felony. That's what this does. Then it also has a provision on the registration for the criminal offenders. It does add RSA 644:9-B. That again, we're talking about, I understand that this may not be a physical act, still a act involving lewd images especially involving a minor. And I don't have a problem with that, especially protecting the minors. I have a hard time objecting to that. And I'll open up for discussion if anyone wishes to speak on it.
Hey, Mr. Chairman, I'm just looking, here comes Senator Khan. I can see what this amendment is trying to do. And I think that just an RSA 469, okay. My concern is with the registration. So if someone's convicted guilty of a misdemeanor for the first offense, are they going to be placed on the sex offender list? Is that clear? Because I can definitely see under Roman 4, anyone who sends a photograph to a child be considered to be on the sex offender list. But if you're talking about someone who does it once, is that automatically gonna put them on the sex offender list?
My understanding, and this is RSA 644:9-B, Roman numeral 4, paragraph 4. That's referencing the Roman numeral 4 that says, notwithstanding paragraph 2, any person who violates this paragraph by transmitting such an image to a child shall be guilty of a Class B felony. So my understanding that would involve when the recipient of the unsolicited image is a child. They would be put in the registry. I don't believe if the recipient's an adult, it would necessarily invoke that.
I think we'll talk about that on our side. Okay.
Any other comments? Any other?
Can we take a few minute break where we can
Yes.
confer?
Yes, we can. We'll take, we'll reconvene at 10:50.
Um,
Morning, we're now reconvening the committee conference on the House Bill 296 and Act establishing the crime of unsolicited disclosure of an intimate image. There was some discussion, and there was amendment 2021-2000H. And is there any, I would ask there to be some further discussion?
Mr. Chairman, thank you. As I said, this was another bill where we only had one person testify, which was you, Representative Bill. And since that time, we've gotten some input. There is a version that was adopted by the Senate, and again, that's why we're here. We have the side by side, and we've received this morning. There seems to be a lot of, this is a very important piece of legislation. And we want to be very, very careful about what we're doing. We know that in today's society, people do this all the time. And for whatever reasons, I don't, for me, I don't know, maybe it's a generational thing, or it's like, why would you do this? But people do this. And so what we're looking at here is really a division between adults and children. And we're struggling with the adult behavior because someone can send you a picture and it's like, yeah, most adults will go, yeah, whatever, and throw it away and not really pay that much attention to it. You have people that solicit these types of pictures. And so we're just concerned about really scooping up a whole bunch of people, especially adults, that you really don't want to scoop up. So I'm hoping that we can agree as a starting point that children, that this happening to kids, but because children cannot give their consent, that perhaps we can just kind of focus on kids and what happens to children, because I think we can all agree that for a child to receive on a device, whether it's an iPad or computer, or if kids are have cell phones, that is unacceptable, that no child should get these types of photos. Even if they're kids trading amongst themselves, we know kids do this stuff, that it's inappropriate behavior and it needs to be addressed. That's where we are. And it's just a question of finding the right language that will focus on minors. And at another point, and probably as a second part, perhaps legislation can get filed that will deal with the issue with adult behavior. Because that's what we're struggling with.
So may I inquire of a question? So if Roman numeral 2 and 3, well, let's just say those two Roman numerals weren't there, those paragraphs were moved. So I think we all agree paragraph 4 is something that y'all like. Is that one of us? Now, I read this as technically the technical language that a child could solicit a intimate image. And that's something that they could do. And technically the person wouldn't fall under this because it was solicited. This has to do when it's meaning that a child is receiving this intimate image without any act of their own to actually justify it being
I
sent.
think it needs to be made clear that the child does not have the ability to consent. So even if you've got two kids that are, trading these, they want to, hey, I want to send you a picture of this, and children legally don't have the ability to consent to either send or receive those images.
But I think consent for statutory rape purposes, I want to say, you're correct, but I'm not clear that consent would apply here. And I think that's just because, keep in mind, the image is going back and forth, especially if the image involves a child, is still going to be following the child pornography law. So whether this passes or not, that's still going to remain the law. So that's still going to remain a crime. It's also, I guess I'm just, would we change the language of paragraph 4 to put that in there, that in any circumstance?
put the word knowingly before transmitting. Like knowingly transmitting the image. So it falls upon the other person, not the child, to be responsible enough to know that they know that they're sending it to the child. And they can-
The problem that it creates a defense, well, I was sending this out, I didn't know it was going to a child. So,
But then again, I guess you could go the other way too. If an image is sent and they missend it and the child ends up with it. And that is not the same situation.
Well, I understand that missending it can happen. Again, people are gonna send intimate images and they send it to the wrong recipient. I don't know, I'm not sure what, I don't know what to say.
Yeah.
I understand what
This
you,
is what
it's a good point,
Yeah.
but
we're
it's,
struggling with.
what do
This is
we,
a conundrum.
how do we justify the action because they typed in the wrong number? And you still have a recipient on that. is-
You
is
you
our
may
vic-
have a person that has a number that previously belonged to somebody
Yeah.
else, right?
Correct.
So I still think you're looking at the act of sending it, right? Like,
And
don't be
this
sending
is-
naked pictures of people.
Well, that would be the golden rule. Don't do it.
I'm just
Don't do it. Right.
Someone, so sorry, I just looked it up, 645, :1, indecent exposure and lewdness law. To, letter C, so a person is guilty of a misdemeanor, such person fornicates, exposes his or her genitals, or performs any act of gross lewdness under circumstances which he or she should know will likely cause affront or alarm. A person is guilty of a Class B felony if, and then C is, such person purposely transmits to a child who is less than 16 years of age, or an individual whom the actor reasonably believes is a child less than 16 years of age, an image of himself or herself fornicating, exposing his or her genitals, or performing any other act of gross lewdness. So the situation we're talking about is already a crime.
Mhm.
So sending it to a child is already a felony. And so I'm not really sure where the issue. The amendment's supposed to be fixing the perhaps accidental, yeah. I guess what we're like, I'm just confused. I feel like what we're talking about is already a crime. So this really is just for adults. Submit like
I think-
against other adults.
I think what this does though, in this particular case, if it's two adults, and the sender and the receiver, the first offense will be a misdemeanor. If the second offense can be a Class B felony. But if the recipient is a child, although it's already a crime, what it's saying is the first offense there will not be a misdemeanor. It will be a Class B felony. And they're bypassing. But if that's already the law, then I suppose we don't want to change that or confuse that issue by passing removal 2 or 3. Even, let's just say we passed, whether it's the House version or if we took the amendments made in the other body, I mean, that reduces it to a violation. And I go back to that. When it comes to prosecuting that, if it's a violation, one, the person's not facing any jail time. You take that the distance and you're not going to have, those shouldn't, and I would not, in respect to the fact it's a violation, it's going to just naturally be low priority. So making it a misdemeanor at least gives it some teeth. And if this is happening all the time, part of it is that, well, there's no penalty to doing it. And
Yeah.
that's why it's running rampant. And apparently something needs to be done. And at this amendment, I think put some protection in there. And I think it's strengthening or clarifying the law already. And if you send the photo accidentally to the wrong person, I sympathize with the situation, but just
Yeah.
I would hope you're very careful with what you're sending out there, because what you're sending out there will be.
Right. Well, if we can look at, I mean, the Senate version didn't deal with separating out adults from children. And you're right, Representative, there is a whole nother statute, and that was part of the problem, because we had people talking about revenge pornography, we already covered that. So if you look at what the Senate did, we changed he or she with person. But it's with the intent to harass, that they're doing it to harass you. Now, if somebody sent by mistake, sends you a photo and you're like, wait a minute, I don't want to see this. Did they do it on purpose? Did they do it to harass you versus was it a mistake? And you look at the House language, you have annoyed or alarmed. I don't know how does that work? That's why we use the word with the intention, it was sent deliberately to you to harass you in some manner. And then it says the person knows the recipient has not consented. You didn't ask for it. They sent it to you. And you did not consent to receive it. And that you were you felt harassed by the image. And then it says, any person who violates the provisions of the section shall be guilty of a violation, the first offense, and a misdemeanor for the second or subsequent event. If the court finds the person has been convicted of a violation of this section. So that's how we got to where we are. I think this is confusing people. And I understand, why that's there, but you're right, Representative, we already have the statute for kids, so why is this even here? And I think the idea of putting these folks on the sex offender list, is a very, very serious something, because once you're on the sex offender list, it's virtually impossible to get off. And so how do these folks get on this list? And what's the criteria for getting them on the list? So I would like, if we're going to look at this, I'd like to not deal with the sex offender list issue, quite frankly, because I think you're going to capture people that you don't really want to.
The statute that the representative identified for public indecency is included on the sex offender list already. So the statute's already written and it's already dealt with on the sex offender list.
I guess the concern would be is that would any version that's passed, whether it's the House or the Senate amendment, would that water it down to the point that, well, what is now Roman numeral 4 on the proposed amendment, would that not be the case? Then it sounds to me like what we passed already would actually remove children from, if the recipient is a child, we're now removing them from being put into the registry, and it's going to be a violation. So this amendment was to address that, because I don't think that was what any of us wanted to do. I think I can say that for all. So are we in agreement on that at least? Whether we whether we follow the amendment or not, but I'm saying is what we pass. I'm not going to support what was originally passed, and I'll take responsibility. I voted for it in committee, I voted for it in the House, but it's been brought to my attention the unintended consequence. So thankfully I have an opportunity to correct that mistake. So I still think this is something that needs to be addressed. Whether we address it now or next year, I guess it's really the question. But I think what this does is I think it fixes the problem, because I don't think anyone wants to make it so a child can receive an unsolicited, image, depicting a sexual act, and the person who sends it can be victim of a violation offense, a fine.
My concern is we already have that captured in statute already, and I'm concerned that if we pass this, you could get a conflict. And this is the problem of not having the time to really look at what's already in law and what's being proposed.
What was the RSA that you referenced?
645.
Additionally, there was a harass. She also mentioned harass. That's multiple times, right?
Well, it could be evidence of that.
Yeah.
I mean, you can make it, if you do it 3-4 times over.
Right. It's pretty evident that's your intention.
Yeah, and this is where you don't want to capture the person who, my God, I accidentally, I
Right,
texted it to somebody
Right.
that I shouldn't have texted it. because
delete it, you move on. But when a
Right.
person's receiving multiple
Multiple, yeah,
over and over, which.
Yeah. that is.
That-
But the
Okay.
point that I'm making is whether it's the House version or with the amendment that happened thereafter. If that, I don't think we can advance that, because the problem is with that is arguably the RSA here on point, it will conflict with that. And I think in that case, if you do send a child a nude image, that it would be nothing more than a violation. I don't think we want that. So if we're not gonna move forward with the amendment, I would not support going forward at all. And
Yeah, I
I
think
say
this
we work together and try to resolve this
Yeah,
next year.
I would
Because-
tend to agree, because again, this is an extremely important issue. And unfortunately, on our side, the only testimony we had was from you, Representative. We didn't have the legal community, none of the advocates. They've all chimed in now at the very last minute with possible amendments and, and we just need to be really careful about what we're doing here. And I just don't want to create a law that is going to catch a lot of innocent people who've made just a very simple mistake. And granted, look, I'm not judging anybody. If you like to take pictures of yourself, that's fine. But sometimes it happens that someone makes a mistake and they send it to the wrong person. And I just can't see that person, being held to a really high standard. But we already have in law that particular RSA, which would cover, which would cover children.
It may be worth noting that the thing that's currently in law is both broader and narrower. It's narrower because it defines adult as 16 and under rather than 18 and under. It's broader because the crime is defined as fornicates, exposes his or her genitals, performs any other gross act of lewdness. That's broader than the conduct that's in the existing bill, so it captures more images than what's proposed here.
Right,
So we're behind schedule. That's also
that's okay.
just comment. We have one of the sponsors of the bill is committee, and I will say I supported the underlying.
I think we all do.
I think we all support the concept of what was trying to be accomplished, but I'm worried about the unintended consequence of now reducing the penalty for the minor proceeding. I take some of the responsibility for missing that. Not perfect, but it happened. But if I'm not comfortable proceeding to any amendment unless we adopt the one that we proposed. Just from our conversation, I'm not sure we're going to get there. So if that's the case, do you have any thought on that?
I mean, I understand. I don't know who's accidentally sending photos. That wouldn't be a crime, but I understand that
I don't
not
sympathize.
always gonna get my way. And that I don't think of all things. I really like this amendment. I think it fixes all the problems. I think all the issues we've talked about are already addressed in law. That's what it is.
I will give you my word on this. If this amendment was to be filed as a House bill next year, I will co-sponsor with you.
Thank you.
And what will happen is, see how it fares in one committee. We'll try our luck. Have a lot of surprises in there, but we'll see. But if we don't have the support to put this forward now, I would respectfully say we advancing on what, receding on or whatever, it's not going to work either.
I would join you in that effort. I think, I think this amendment is improved.
Does anyone else wish to add any comment to that, or? Happens to all of us. I'm even with you there. it's what it is. So what we'll do is we won't give up on this issue. So
No. it-
Co-sponsor it.
There's gonna be legislation. We already know from other senators that are very interested in this issue. So it will come forward.
we're not, what the terminology is,
We're very close.
we are close, but when
Yeah.
the failure to reach any
We
concurrence,
can't retain it.
so there's no proceeding or not gonna be any concurrence in this, so.
We need more time and we need work on this issue before we can bring it forward.
There we go.
Thank you.
Clouds are expensive.
Good morning, everyone. We now call the order the committee conference on House Bill 334. Does not have the title in it, so if someone could kindly read the title of 334, that would be appreciated.
It is relative to prohibitions on carrying a loaded firearm on an OHRV or snowmobile.
And just, everyone can please just introduce themselves.
I'm Senator Bob Snyder from District 2.
Senator Carson from District 14.
Senator Jay Khan from Keene and Cheshire County.
Representative Terry Roy from Rockingham 32.
Representative Scott Wallace, Rockingham 12.
Representative Jennifer Rhodes, Cheshire County, District 15.
Representative Daryl Avis, representing Rockingham County, District 8. And I think there was an amendment that passed in the Senate, and I'll just allow that to be explained, if you don't mind, so.
Thank you, Mr. Chairman.
Oh, you want me to? Or do you? Well, because I'm the one who did it. Oh, no, you did it. Okay.
So the amendment was essentially to attach a bill of similar substance, Senate Bill 141, to do away with the state police gun line, which has been problematic. That bill passed the House and the Senate, is currently in the enrollment process. What we want to do is belt and suspenders with this amendment to ensure that it gets passed. Nice way of saying. That's essentially it. That's the legislation that was passed by the House and Senate. Senate Bill 141, we've attended to this to bring this forward as a belt and suspenders for the bill that is currently enrolled, but for which we have no assurance of signature.
Is it, if I may inquire, this amendment, is it, may I say word for word, or at least almost word for word,
It is,
what was Senate Bill 141
it is.
that is passed in both the House?
There's one point that we just found out from OBA, that in the final language, I believe, after section 9, the effective date and language there are two. There's an amendment in because Representative Umberger wants to put into this bill abolishing the actual positions that deal with the gun line in the state police. And that amendment is currently almost, it's in printing literally as we speak. So I'd like to request a recess for 5 or 10 minutes until that is done. Tracking that. Again, we just found this out about a half hour, about an hour.
So I will say we're behind schedule. We do have, there is another committee conference for House Bill 45 that was scheduled for 11:30. We could move on to that and put this the recess at 3:34 right now. We'll be in recess. The committee conference on House Bill 334 will be in recess.
Thank you.
we will start by just allowing everyone to introduce themselves, starting with yourself.
Harold French, Senator District 7.
Senator Carson, Senate District 14.
Senator Jay Khan, Senate District 10, representing Keene and 15 towns in Cheshire County.
Representative Terry Roy, Rockingham 32.
Representative Scott Wallace, Rockingham 12.
Representative John Bourdon, representing Cheshire 5.
Representative Darrell Apis, representing Rockingham County District 8. So we can begin. This was, there was several, well, not several, there was an amendment that added several provisions to this that I would say, I want to say unrelated to the underlying bill, but is there, a lot of those, my understanding, have either passed or been resolved in other legislation.
Yes, if I may, Mr. Chairman, as you know, we've been meeting in a variety of committee and conferences over since Monday. And we came to an agreement on Senate Bill 40, which was filed by Senator French, which dealt with this very same issue of the underlying 485. And I had attached a bill to this because we were concerned we were going to lose the bill. But yesterday, the committee of conference met and we came to an agreement. So that language is no longer needed either. So my recommendation is this bill, we don't need this bill in its entirety.
I agree with you. Does anyone else? Any other further comments?
Which bill did the laser thing end up in?
Yeah. Senate Bill 134, and we came to an agreement with the House yesterday.
And I know there was an issue with the police in Rockingham County involving some of the recording of plans. That was resolved yesterday as well, so.
Yeah, the amendment was a hybrid of both the House and the Senate version. We worked off of the House version because again, you had language in there that we did not, that we had agreed with. And there was just one other section in there that we were concerned about, but we came to an agreement.
Search of vehicles and corrections property.
Yes,
Yeah.
we had
Yeah,
to
we
make the
took care of
correction.
Any other comments? Looks like that we are not gonna proceed and there's not gonna be any, there's gonna be no
There's no
concurrence, so no action to be taken.
Thank you. So we'll wait a few minutes on Senate Bill.
the committee conference on House Bill 334. My understanding is that there was an amendment pending. It's now been prepared. And Senator Goddard, you mind
Thank you,
explaining
Mr.
that
Chair.
amendment to us?
The amendment fixes some technical details. With your indulgence, I would ask Kevin to speak to it. Mick, I'm sorry, Mick, to speak to it.
You may speak freely,
We'll
sir.
make sure we don't get confused.
Good morning. For the record, Mickey, yeah, I think it's on. For the record, Mickey Landrigan with the Legislative Budget Assistance Office. So I can walk you through Amendment 2014S. So there are a couple budget technical corrections being made here in line with the intent with Senate Bill 141, as well as the language that was inserted in House Bill 334. So starting with Section 9, this would be the $100,000 appropriation to the county sheriff's office. The language that's in both Senate Bill 141 and 334 makes that a charge to a certain class line and accounting unit in the Department of Safety in fiscal year 2021. Those funds are not available in that amount to do the intent here. So if you look at Amendment 2014S, Section 9 would be replaced by a straightforward general fund appropriation in fiscal 22 for the same purpose. In Section 10 of Amendment 2014S, this would be the abolishment of 3 positions in the Permits and Licensing Accounting Unit. And if you look at on line 15, paragraph 2, you'll see the corresponding general fund appropriation reduction for those positions. So there is a net here of about a $300,000 budget reduction in this amendment to reflect the intent of the gun line abolishment in the bill.
Mind if I inquire a question? So this was that $300,000, $100,000 reduction in spending, did I hear that correctly?
The $100,000 would be a state spend to the counties, and then there'd be a $400,000 on line 17 appropriation reduction in the Department of Safety for a net of $300,000 spending reduction.
In a follow-up, that $401,650, is that, what was that money? What is that going to go to fund what was referred to as the gun line?
Yeah, that is included currently in House Bill 1 that the conferees have signed off on that report. So those 3 positions you see listed on lines 12 through 14, that's the funding associated with those positions. They are in the budget. This amendment here would abolish those positions from the budget and take the money from the budget.
Thank you.
Interesting, seeing that the fiscal note on 141 was $87,000. So I'm just wondering where the math came from for this.
Math for this, if I may, Mr. Chair,
Yeah.
came from the actual cost of the lines for those positions. Right? The 401,000, that's the jobs that are being eliminated. And the 100,000 is the money that's going to the county that we can't appropriate from the year's money. It's for the 10,000 in each of 10 counties to set up the system in each of those counties.
So what elicited the question is, it just seems like a big jump, big difference in the numbers. If the fiscal note was 87,000 and we're eliminating 400 or 300,000 roughly from this, why the? was
Well,
that
there's been some changes in personnel. Safety has hired some personnel to restaff the gun line. Okay, subsequent to that bill being introduced, they had 8 troopers off the line. We don't get the details of the bill because it's been passed by the House and the Senate. They took 8 troopers off the line to staff the gun line to catch things up. Now they're adding 3 personnel. Those 8 troopers go back to the line. Those 3 personnel are coming out of the budget.
It's from my field trip to the gun line 3 or 4 weeks ago. There's 1 trooper that's assigned currently. There were 8 that during the COVID, they weren't out on the road doing it.
I'm not going to argue the merits of the bill, Representative, because that's already been voted on by both chambers. Correct. All right, 401,000 is the amount of 3 positions for the gun line that are being eliminated by the statute, by the pending statute. That's what this one is.
If I can inquire, so I understand that 141 has passed both and it's on its way, or will be on its way at some point, awaiting a signature. Hypothetically speaking, if that 141 was vetoed for whatever reason. What would then happen if we eliminate these positions, but also the bill is vetoed? Where does that leave us?
If you read on line 18, section 11, addresses that issue.
Oh, thank you. But that was addressed. In fairness, this was just handed to me.
No, me too, so, yeah.
So if for some reason Senate Bill 141 was not signed into law, then those positions would not be eliminated. That's important. Now, is Senate Bill 141, or at least, sorry, the amendment that was made to 334, otherwise it will still have the duplicate language in there as well?
It's the same. The same as 141. This will amend that language in 33, 34. So it's consistent with the budgeting.
I think for the purposes, if we're gonna eliminate the gun line, then this makes sense to eliminate the $400,000 that was gonna be allocated to funding the employees hired to, address the demand that they had to meet. So that makes
Not only
sense.
makes sense, it's necessary.
Whether we support getting rid of it or not, I mean, if it's going, this is the right thing to do.
Mr. Chairman, I'll make a motion that we adopt amendment number 2014S.
I have a question. That if Senate Bill 141 does not take effect, sections 9 and 10 of this bill, 334, would take effect. What I want to be clear of, when it says on line 24,
Senator, if you look at
I-
line
18.
18,
Yep.
the contingency
Yep.
explains how that works. If 141, and we're not talking about this bill, we're talking about Senate Bill 141, which is on its own track, becomes law, sections 3 through 8 of this act shall not take effect, and section 7 of Senate Bill 141 shall not take effect. If Senate Bill 141 does not become a law, section 3 through 8 of this act shall take effect. So if for whatever reason, if Senate Bill 1, the governor vetoes that, you have to leave these other two things in place in order to make the gun line work. So these two parts will not take effect at all.
I will say if you had the gun line in existence and it was unable to work at all, in and of itself would essentially prevent any legal firearm transaction, because at least involving pistols. The state would have a huge amount of lawsuits on their hands that they would likely lose all of them. Because they are effectively denying anyone any lawful purchase of a firearm, at least a pistol, through the gun line, because it's now not staffed. So if you're gonna have the gun line, it must at least operate in a way that it can perform appropriately. If there's no one to operate it and everything's in limbo, not only you have the constitutional issue, all those stores are likely to go out of business.
May I ask a question, Mr. Lundgren?
Yes, sir.
Mr. Lundgren. If Senate Bill 141 does not become law, and Senate Bill 334 does, so 334.
If I may, if 330,
I want, yeah, go ahead. It's,
Yeah,
so it's still on 9 and 10, and wanting to make sure that I understand.
so
that-
hypothetically,
that if the gun line, if the veto takes place on 141, unlikely, yeah, right? But if it happened, then 334 would be there.
and if 334 was then signed into law,
then
Would these contingencies still be applicable? Is that what you're inquiring about?
these are gonna take effect.
If I may.
You-
So I think the intent would be for sections 9 and 10 to take effect if 334 passes, right? Because you've got all the language from 141 in 334 now. So the abolishment of the gun line would occur in 334. In these sections 9 and 10, I believe it's the intent to have those also take effect, the reduction in safety. There's no way for 9 and 10 to become law without.
334.
Correct.
That's the clarification.
Is there any other further discussion to be had?
I just to say I'm in opposition to this, and I'm likely not in agreement with the inclusion of 141 language in the 334 bill. The underlying bill is one that I would like to be voting for, but I believe that the state's role with the gun line in the Department of Safety is a valuable one, and it's working well enough that, and we've heard that through testimony, and so I believe that and support that line of thought. Hence, I will vote against this, but I will likely need to resign from this body.
With due respect to my colleague, this is the position of the Senate.
I can say on behalf of the House and of all each House member to say their comment. We did, the House position was we ended up passing Senate Bill 141. So and we also passed HB 334. So the House position would be to support both. I think this is the fiscal responsible version of what I would ultimately assume we should have happened if you're going to eliminate the gun line. So I don't have a problem with amendment 2021-2014. Does anyone else, anyone have any comments?
I agree with everything you said.
There's a motion. I think we're waiting for, is it seconded? by Representative Moore? Are we all, is one opposition? We just, Representative Rhodes, you're a yay, Mr. Walls.
I share Senator Khan's position. I think the gun line's doing a good job. There has been some problems in the past. I took some time, went out there and did a field inspection. Everything's working well. This is kind of a surprise, not what we were expecting at all today. And to that point, I'm not in support of it.
It is a surprise, I will say that. I'm surprised. But I think with what it is, without knowing what it is, it's hard to comment on it.
I'd like to address the surprise issue.
Well, I'll just say in respect to, I understand supporting and not supporting New Hampshire gun line, whether to abolish or not. I get that. Senate Bill 141 is already on its way up the ladder. So I guess if it were going to pass, and let's say we couldn't get this amendment in, what would happen? Arguably, there would be a few state employees, 3 of them, I believe, with not much to do. So I think is that my understanding? If I'm wrong, please correct me. That's my concern, is that we this probably should have been addressed from the start, but it just was not. So I think we can clean that up. We should. Whether you support the gun line or not, I think we all should agree that we shouldn't have that $400,000 wasted on positions that don't have a task, right?
I would respect the authority of the Commissioner of Safety to make appropriate staffing decisions. Work with the fiscal committee if there was adjustments needed to be made.
So My point is, I think if you support the amendment, you're not necessarily supporting getting rid of the head gun line. It's the cleanup. That's what this is.
And you can understand why, because the bill was filed and there was no budget when the bill was filed. And we were still, I think when the Senate bill went through, the House was still working on the budget, so we didn't have a finalized budget. So I can understand why this happened and why we need to do it. I think it's pretty self-explanatory. We just don't want to carry excess positions and to tie up $400,000 of state money.
That being said, I would agree with you, but we're also in a hiring crunch. And I would expect to be very easily, we could put these other people into other roles within the Department of Safety almost immediately.
I would expect Representative the same, that even if we get rid of these positions, that they're good
They're
employees
remaining
and
employed.
they are going to find a place for them in the Department of Safety. They're not gonna let them go.
Worked on the budget. We know that the Department of Safety requested additional positions. We gave them not all of it, so over time, I'm sure.
Just for Representative Rose, you were in support.
Yes.
Representative Roy.
Yes.
This is of the amendment, correct?
This is of the amendment 2014S.
Yes, I would vote yes.
Yes.
I do vote yes.
Yes.
So,
We need to recess.
I'll leave that on.
no, this is just adopting the amendment. We haven't voted on the bill.
So I vote yes to adopt. So we now adopted the amendment. Sorry.
Okay, so we've adopted the amendment by a simple majority. What we need to do now is to look at the bill and decide the bill as amended.
There's a lot of overlap in what we were saying. At least I was kind of going.
I'm about to pass.
Is there a second?
Second.
And it's been seconded by Representative Roy. Any further discussion on that?
Pass both houses. Both houses, I think.
Yeah, it's
Everything's
already
been said, it's what he said.
So I would go yes.
And I just want to make sure the motion on the table is to accept the Senate version of 334 as amended
As amended.
by the committee.
Which includes 141.
Yes.
We all in agreement on that?
No.
Still not. We'll be waiting for one, and then we would, let's make sure I say this correctly, we will recede to the Senate amendment as amended.
Yes.
Exceed the Senate position as amended.
As amended. I think I repeated myself on this.
Thank you.
Thank you.
Thank you.
Right, that message will be taken to the Senate.